We'll now hear the case of Laura Tanner versus the state of Ames. Counsel?
This is the 110th anniversary of the Ames Competition, but it is the very first we are doing entirely virtually.
Mr. Chief Justice, and may it please the court, Ames can seek to protect its citizens from the harms of non-consensual pornography, but it cannot set aside the First Amendment to do so.
To start from the beginning, the Ames Competition is the moot competition at Harvard Law School. It starts in the first years, and then folks who really like it try out our qualifying round, and then from there they can go on to the semifinals, which is only 4 teams, and the finals, which is only 2 teams. So from the beginning, they're working on an appellate case, and by the time they get to the final round, they've taken it all the way to the Ames Supreme Court, which is what we call our fake state of Ames.
I got to see Ames for the first time my 1L year, and I'd never really seen anything like it. I'd never gotten to see a full appellate argument before, and I kind of immediately thought this is something that I might want to do.
There's just so much attention on it and so much excitement, and the campus is just all surrounding this one event.
What's most fun to me about Ames is the opportunity to come up with legal arguments and to exercise creativity in that way.
The research, the collaboration, the back and forth process of building an argument.
So really, I just wanted to do Ames because I wanted to talk about hard legal issues with my friends.
The coin toss is traditionally the way the 2 sides of the argument are allocated. So the side that wins the coin toss gets to determine whether they'll be petitioner or respondent. They don't know the issue yet, but they do know whether they're defending the decision below or critiquing the decision below.
So the Lorin Gaines Memorial team will be calling the coin toss, that is by tradition.
Whoever was the respondent in the semifinal round gets to call the coin toss.
I see heads. I'll bring it up here. That was a heads. Okay, Jason. Lorin Gaines Memorial team calls it. What would you like to be, petitioner or respondent?
We choose respondent.
Fantastic. So
Petitioner has to write 2 briefs, and petitioner has 1 oralist who argues twice.
And we were actually quite happy with that. We would have chosen to be the petitioners. It's the side that we did last time. We're more familiar with it, and it was probably what we had preferred.
I think one thing that is both a lot of fun and really challenging about being the petitioner is that you lost in the lower court, and so you want to frame your argument in a way that's an affirmative, all the reasons you should support me, but you also have to deal with the fact that at least some other court, here it's a fictional court, but at least some other court disagrees with you and thinks that the other side should have won. So you're both playing, that defense, but you also really want to put forward an affirmative argument for all the reasons that you should win, not the reasons that you shouldn't lose.
Part of me at the moment was like, my intuition was to switch to petitioner, but I couldn't do that once our team had already decided to go with respondent.
The petitioner kind of gets to frame how the case comes out. They kind of get first shot at here are our best arguments. And so the respondent is a bit of a tricky position because you both have to anticipate, what are the worst possible things that could come up in the brief. So the first stage of our thinking is sort of, if we were the petitioner, what would we really want to argue? And what would we be nervous about the respondents bringing up? And then figuring out how to frame our kind of counter arguments along with our offensive arguments. It's a tough thing to get to do in the space of 1 brief, especially because we know we only have 1 shot at it. The petitioner has an initial brief and then they have a reply brief.
So the record this year is Tanner versus Ames. So that would be Laura Tanner suing the state of Ames, and she is suing over the Ames Non-Consensual Pornography Act.
The 2 issues in this case, one of them concerns a First Amendment issue and the other is a Fifth Amendment issue. So the First Amendment issue considers whether a state, in enacting a law that criminalizes the non-consensual sharing of pornography, something that's come to be called revenge porn, whether they violated the First Amendment in doing so.
And the second issue is whether compelled decryption violates the Fifth Amendment. So whether the police can force you to enter your passcode into your phone when they're searching for evidence on your phone.
They're both obviously live issues that are pretty important to people's lives and that have sort of important normative considerations on both sides.
I think our first step was to figure out who in the team was going to work on what issue. So we've generally split 3 and 3 on issue 1 and issue 2.
Preparation experience and process is definitely my favorite part of Ames. Let's figure out what the cases say. Let's figure out, what the possible universe of arguments is, and then As we go along, we'll keep refining and narrowing.
You know, in the beginning, we're very, very busy because we're both preparing to actually write something, but also just getting to know the doctrine, the facts of the case, and just trying to familiarize ourselves with everything, but also simultaneously make sure we can get something on the page.
I would say that we're all pretty tired. We've had a lot of late nights this week, but our brief is due in about 2 hours. So we spent the morning doing our final polishing. I have a really detail-oriented team, so it's great to be able to read through a draft in the morning and find no typos or errors. That was really exciting.
This round in particular, we were pretty intentional about leaving some arguments out from the opening brief because we didn't want to sort of make their arguments for them and then have to argue against them. So there were a few points in particular that we wrote and then removed from the opening brief and saved for the reply.
You know, I think we have a lot of respect for each other's intelligence and ideas on the team. So I think even as we're tired and we've worked really hard, I think we're really proud of the product we're turning in this afternoon. So it feels great.
When you're doing a Supreme Court argument today, you know who your 9 justices are. You know, the famous phrase is count to 5. With Ames, though, we have absolutely no idea who our judges are going to be. So that really changes the calculation about how you write your brief. And it depends a lot more as respondent on what petitioner argues.
We've already written a fair amount of our briefs, sort of with like placeholders and trying to kind of guess what they might be going at.
The only thing that really changed was just that they spent less time developing their argument in a few sections where we thought that they were going to spend more time. And we thought that kind of opened up some opportunities for us.
Their opening brief, I don't feel like it anticipated our arguments very much, in part because our arguments were so, I don't know, I'm really excited about our arguments, but they're not, they're novel. They're novel arguments.
Once we have the respondent's brief, we have another week to write a shorter reply brief. I know last round, that was my team's favorite part of the competition, where you get to have, you know, the punchiest version of your argument. The last word is really fun.
It was fairly surprising. I think it was pretty clear that we were thinking of the issues pretty differently than they were thinking of the issues. Not just sort of point counterpoint, but more of a meta difference in terms of how to address the issues.
When you're not an oralist, a lot of your preparation is sort of getting to be mean to your teammates who are preparing to be an oralist, right? We mooted for hours every day for the weeks going up to oral argument.
The mooting is fun. It's a chance to poke holes in our own argument, and having sort of lived with it for the past 2 months, we know, where the soft spots are. Also always fun to pretend to be a judge for a few minutes and to get to ask some tough questions to one's friends.
Intellectually, I just also think it's really challenging to kind of think through the full implications of your answers. So, if I say something, Mike and Lorin and, the other 3 team members on the other issue will be quick to be like, hey, well, have you totally thought through how that could set you up 2 questions down the line? And I think just like the level of precision that is required to do a successful oral argument, I think is something that is challenging and fun, and I learn a lot from.
I mean, it's just amazing to have Justice Breyer on the panel. He's done Ames a number of times. He has a reputation for having a very individual jurisprudential style and oral argument style. We were like, we need to practice, mooting more Justice Breyer style questions.
So it probably took me like 20 minutes to walk to campus, do the COVID test, and then sit down, and you're in this kind of conference room type thing. And it's kind of bizarre because Jason was right next door.
It was really weird. I think the weirdest part was being able to communicate with our team beforehand, and it really felt like you were in a spaceship, kind of before liftoff, everybody in their little pod talking to each other, we're 2 minutes to go.
All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting.
Counsel?
Thank you, Mr. Chief Justice, and may it please the court. The Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness against themselves. But the compulsion...
One thing we worked really hard on was preparing our oralists for these sort of long-winded hypothetical questions, especially from Justice Breyer, because he's sort of known for these, long, really interesting, almost law school hypotheticals.
I have all the evidence in my house, 10,000 pounds of cocaine. And where it is it's in the basement. And by the way, I have the basement totally locked, and I have the key.
Two differences here I'd like to point out, Your Honor. First, when you hand over the key in your hypothetical, you don't actually say anything explicitly. That's different than the case where you say your password.
It really made it feel like we were in a real Supreme Court argument and that he was treating us, like petitioners he actually sees in the real Supreme Court. So that was really fun.
Their client received what we normally consider a pretty obscene picture, and she sent it to the executors and she said, "Look at this, my friends. Look what goes on here. That message is designed to change the world that she's in. It is hard to think how this statute doesn't put her in jail for doing it."
Your Honor, the First Amendment does not straitjacket the state to be unable to respond to crucial social problems. It, in fact, strikes a balance between petitioner's need to express herself and the other social harms that this speech endangers. The straitjacket line was actually an allusion to a plurality opinion he wrote. I didn't want to actually cite the name of the case or be Justice Breyer, as you said, because the facts of that case were kind of different, and it was a plurality, and the case name was really long. But I kind of just was said that word as, I don't know, maybe subtly being you kind of agree with me on this general principle.
It was very difficult for us to make a decision. The best oralist, after discussion, we decided was Travis Fife. The best brief, we decided was the petitioners, and the overall best team we decided was the respondent. And it could have been the other way around, I promise you, but very, very good for all of you.
It was surreal, honestly. I think if you had said to me on the first day of law school, you're gonna win Ames, I'd be like, what are you talking about? That's the craziest thing I've ever heard. Win or lose, it's very cool to be part of this tradition. It's, I think, one of the best things about Harvard Law School.
Having 6 people write a brief together, I think, is a really unique experience, and you learn a lot about, what makes you a good team member and sort of how you fit into a team dynamic. And I think this was a really special year and that we worked really hard, and I'm really proud of us for rising to the challenge.